Morning. We're opening our session this morning. We're going to take, however, about a quick 5-minute recess before we begin our process because I have to take care of some matters of state. Everyone would please rise and join me for the Pledge of Allegiance. I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
This one I'm gonna retain, so everything except that one.
I hereby open the executive session on House Bill 257 and recognize Representative Rhodes to make a motion.
Thank you, Mr. Chairman. I move to retain House Bill 257.
Your second? Seconded by Representative Scher. Would you like to speak to your motion?
Sure. Thank you, Mr. Speaker. Just kind of a little bit of a recap. We passed this bill out of the committee. I do believe that the committee was split on exactly if it should pass or if it should not. Then there was some questions the day of the House session, and you actually had asked for the bill to be resubmitted back to the committee. And really, the way it is just there's just a lot of confusing language. There's a lot of stakeholders that have concerns, but don't necessarily think it should be killed. So I think maybe let's retain it and see if we can do something with it over the summer.
Thank you. Representative Scher, would you like to speak to your second?
Yeah, I'm obviously I'm in support of the motion to retain. Yeah, I've submitted an amendment that is one way to deal with what I think is a difficult situation, protecting children, but also not over criminalizing lousy parenting. And it's a hard issue, and it's worthy retaining to think about it some more.
Thank you. If I'm not mistaken, there's also a bill in the other body that may somewhat address this.
That I'm not aware of.
Yeah. All right. Thank you. Any further discussion? Yes.
Actually, one more thing. I know we passed a bill that deals with a portion of this, that is children being exposed to situations where there are drug users. And I think, it's worthy considering what we do with this bill in light of taking care of that piece.
Thank you. As part of the retaining process, we'll definitely delve into all of that. If there's no further discussion, I would ask the clerk to call the roll. The motion on the floor is to retain.
Vice Chair Rhodes,
Yes.
Representative Prue,
Yes.
Representative LaSalle,
Yes.
Representative Devoid,
Yes.
Representative Gagné,
Yes.
Representative Labrie,
Yes.
Representative Sabourin Deschrenier,
Yes.
Representative Tudor,
Yes.
Representative Harriet Gathright, Representative Muse,
Yes.
Representative Newman,
Yes.
Representative Murphy.
Yes.
The clerk votes yes. Representative Newell,
Yes.
Representative Scheer,
Yes.
Chairman Roy,
Chair votes yes.
16-0.
16-0. The motion carries. The bill is retained. I hereby close the executive session. I hereby open the executive session on House Bill 369 and recognize Representative Murphy to make a motion.
Sure.
Wait a minute, maybe not.
I think it's the wrong.
Oh, I think I'm on the wrong bill. Who's this one? Okay. Stand by. Excuse my previous notification. This bill is to us on a second committee, however, was listed on my executive session sheet. This is not a public hearing. I mean, excuse me, this is not executive session yet. This is a public hearing. Is there anyone here to introduce this bill in our committee as a second committee? Well, I think we have to, part of the second committee. Yeah.
Right?
Yeah. Yeah, it's a second committee. We have a regular hearing.
I feel like Brad needs to tell us something.
You can waive it. Okay. Anyone wish to discuss this bill while we have it before I open an executive session on it? Representative Rhodes?
Okay, what I was saying is I said that. Oh, there's my paper. All right. So my understanding is this bill did already go to judiciary and it passed on the consent calendar. So there is support from all the stakeholders on this particular bill. My understanding is this bill is going to help streamline the court proceedings in cases involving minors, survivors of sexual assault, improving what can often be a daunting and scaring process for children. Yes, I have a piece of paper. And read about where it goes in the next bypasses.
Okay, the way this is written, under the current law, child victims may face a second criminal trial should a finding of guilt in the lower court be appealed. HB 369 changes this process by requiring the defendant to decide whether to proceed to the circuit court with a bench trial or immediately appeal to the superior court for a jury trial. The bill, so this streamlines and avoids a child having to go through two trials. The bill recognizes how incredibly difficult it is for children to come forward after they have been abused, and a small measure will take to limit the long-term trauma that survivors and their families face. Anyone else wishing to weigh in on this? Representative Scheer.
I'm going to oppose this bill, not because I don't understand the goal of the bill. I am just, I am deeply troubled by starting to screw around with the way the system works and making exceptions. Once we start making exceptions for this kind of case, maybe we make an exception for another kind of case. As a matter of principle, there may be other ways to deal with this circumstance, but I don't think giving a defendant who's charged with a particular thing less statutory rights than other defendants do is a good approach to deal with this circumstance. So I'm going to oppose this.
Thank you. To an extent, I concur. I'm very wary of bypassing certain procedures and rules that the court put in place. And when we put something like this in and someone can go directly to a different court, it automatically, by definition, increases the burden on that court. Having said that, I believe that in cases when we're talking about children who have been victimized, if there is ever a reason for an exception, it would be in their case versus making them go through another trial. Indeed, especially for sexual assault prosecutions. So having said that, anything else? Representative Murphy.
I just want to say thank you, Mr. Chairman. I agree. As a parent of a child that had that experience, I don't think unless you live with it, you recognize the impact, the lifelong impact of not only the assault, but what follows, the court follow-up. So to have to go through two trials for a child is I think it's one of those places where we make exceptions and carve outs in other laws, and I think this is one of the worthy places. Thank you.
Thank you. And I agree, having investigated some sexual crimes against children, the impact on them is incalculable. Representative Newman.
Yeah, I just wonder about the analysis of the bill says a defendant under 16 has to make a decision. Does the actual wording of the bill say, would it require a 13-year-old for that person to make that decision?
I think that with regard to the court, and Representative Scheer can correct me if I'm wrong, the parents or the adult involved with them would work with them in making that decision. It would never be just put on them to make it.
Thank you.
You're welcome.
Thank you.
Without anything further, I'm going to say I'm closing the public hearing session of that, if that's what that wasn't. Now we're going to go into executive session on House Bill 369. Any further discussion? Seeing none, can I get a motion?
Mr. Chairman, I'd move ought to pass for House Bill 369.
Second.
Seconded by Representative Murray. Seeing no need for further discussion, I'll ask the clerk to call the roll. The motion on the floor is ought to pass.
Vice Chair Rhodes,
Yes.
Representative Prue. Oh, sorry. Representative LaSalle's,
Yes.
Representative Devoyd,
Yes.
Why is he-
Representative Gagné,
Yes.
Representative Labrie,
Yes.
Representative Saborn Deschenier,
Yes.
Representative Tudor,
Yes.
Representative Harriet Gathright, Representative Muse,
Yes.
Representative Newman,
Yes.
Representative Murphy.
Yes.
The clerk votes yes. Representative Newell,
Yes.
Representative Shear,
No.
Chairman Roy,
Chair votes yes.
14-1.
14-1. Do you object to consent? No objection to consent. The motion carries. It will be on the consent. Next, I open the executive session on House Bill 240 and recognize Representative Saborn Deschenier to make a motion.
Thank you, Chairman Roy. A motion not to pass.
Motion made and seconded by Representative Rhodes. Would you like to speak to your motion, Representative?
Yes, this bill changes the language in RSA 466-14 from shall to may. Local governing body may, within 20 days from June 20th, issue warrants to local officials for civil forfeiture for unlicensed dog. An unlicensed dog is not necessarily a nuisance dog, and this is a pro-liberty bill. It relieves burdens on local governments, and it also promotes, more autonomy with dog owners.
Thank you. Representative, would you like to speak to your second?
Thank you, Mr. Chairman.
Thank you. Representative Deschenier, can you tell me the part you said about relieves the burden on municipalities?
Right, they no longer shall, now they may.
So that saves them from having to issue these warrants if they don't need to.
Yes, sir.
Thank you. Any further discussion? I personally find it odd that we license an animal anyway, so I'm in favor of anything to do downplaying of that. Having said that, no further discussion. Ask the clerk to call the roll. The motion on the floor is ought to pass.
Vice Chair Rhodes,
Yes.
Representative LaSalle's,
Yes.
Representative Devoyd,
Yes.
Representative,
Gagné?
Gagné,
Yes.
Representative Labrie,
Yes.
Representative Saborn Deschenier,
Yes.
Representative Tudor,
Yes.
Representative Harriet Gathright, Representative Muse,
Yes.
Representative Newman,
Yes.
Representative Murphy.
Yes.
The clerk votes yes. Representative Newell,
Yes.
Representative Shear,
Yes.
Chairman Roy,
Chair votes yes.
15-0.
15-0. Any objection to consent? Seeing none, then we'll go on consent. I hereby close the executive session on House Bill 240. I hereby open the executive session on House Bill 597 and recognize Representative Prue to make a motion.
Move ought to pass.
Second.
Seconded by Representative Murphy. Would you like to speak to your second, Representative Prue?
Sure. This bill is allowing the 911 system to transfer non-emergency calls, usually behavioral health calls, to that access point for them, the 988. A lot of people don't know that number, but right now, as I was told, they have no authority to transfer a non-emergency call to the proper help that they need. So I think instead of 911 saying, oh, we can't help you, but you need to call this number, they can just now transfer that over and get them to the place that they need to get the help. So I think this is a good bill. Not a lot of moving pieces in it, just a simple, okay, we're pushing the button and transferring the call. And it allows them to also 911 is very good at taking information, what's going on, what's happening, what do you need? And now they can transfer all that stuff with it. And as far as I can tell, I think HIPAA was preventing that a little bit or something along that line. And now I notice in here that they can transfer all that info and keep tabs.
Representative Rhodes, would you like to speak to your second? Excuse me, Representative Murphy.
No, thank you. Thank you. I think you did a great job. Thank you.
Thank you. I concur with everything you said. That seems like we're unraveling some red tape to make things simpler and possibly save lives. Representative Scheer.
I've done a lot of work as a Portsmouth Police Commissioner, helping the police department connect with the mobile crisis units, which are different than not the 988 number, which is primarily a suicide number. But I know I'm comfortable that this doesn't get in the way of the work that 911 has been doing with mobile crisis units also. So I'm in support of this.
Representative Prue.
I tend to agree with you, and I think it enhances that ability to get to the mobile crisis. Because I would really like an easier number than what I have to call when I'm looking for them.
Excellent. Feel the love. I ask clerk to call the roll. Motion on the floor is ought to pass.
Vice Chair Rhodes,
Yes.
Representative Prue,
Absolutely.
Representative Lascelles,
Yes.
Representative Devoyd,
Yes.
Representative Gagny,
Yes.
Representative Labrie,
Yes.
Representative Saborn Duchenier,
Yes.
Representative Tudor,
Yes.
Representative Harriet Gathright, Representative Muse,
Yes.
Representative Newman,
Yes.
Representative Murphy.
Yes.
The clerk votes yes. Representative Newell,
Yes.
Representative Scheer,
Yes.
Chairman Roy,
Chair votes yes.
16-0.
16-0. Any objection to consent? Seeing none, it will go on consent. I hereby close the executive session. I open the executive session on House Bill 602 and recognize Representative Murphy to make a motion.
Thank you, Mr. Chair. I'd like to move Amendment 1096H, and motion ought to pass. As
I'll
amended.
second your motion. Would you like to speak to your motion?
Certainly, thank you. I think we had some good testimony during the public hearing. There's no question that DUI cases are on the rise. Law enforcement and the courts are doing their very best to address it, but there are additional steps that we can take that will certainly improve outcomes. And I think this would put another tool in the toolbox for those that are trying to keep our roadways safe and protect the lives of New Hampshire citizens.
What would your amendment do?
The amendment actually removes the, I'll show you, it is on lines 10 and 11. The amendment was requiring the fee for the program to be paid for by the participant, and it remains that it's no cost to the state of New Hampshire or to any county.
Okay, thank you. Anyone have any questions? Representative Rhodes.
Oh, thank you, Mr. Chairman. And I would like to thank my colleague. We did have a conversation over in the State House about some concerns that I had, and she brought an amendment that did address that. So I do thank you for that. But I do have a couple questions. So I'm looking at line 13, where it says required to complete qualified online victim impact program payment as defined unless the court determines the exceptional circumstances exist. Could you give an example of what does that mean exactly?
Sure, thank you. That was language supplied by Erin Cregan from the courts, and she said that's pretty consistent language used for if a person is severely developmentally delayed or there's a language issue. She said it's not often used, but it allows the discretion of the courts, and she said typical language. And it was their request that I put that in.
Okay, and may I ask another question, Mr. Chairman? So I read your email last night, right, where you had said about basically everybody pays, right?
Yes.
So what would happen if a person doesn't have the ability to pay?
Well, that was written into the bill to allow for that. I think when we reviewed, I spoke with, actually, let me just grab it, to a person from the Attorney General's office, and again, Erin Cregan as well, as to how the courts work, the fines and the fees. And they said that the fines are just non-negotiable. The defendants just have to figure it out. They said if basically, if you do the crime, you're responsible for for meeting the obligations of that fine, and you don't get your license back until that has happened.
Did we not just pass a bill that allowed the court to let people take time to pay fines? Was that on a
Yeah,
specific?
on driving fines. Yep, we did.
And from what I understand from the courts, that there's a $25 fee that they can pay that to ask for an extended payment plan. So that's an option for defendants after conviction.
Thank you. Representative Scheer.
I'm opposed to this amendment in that it treats individuals the same in spite of their very different financial circumstances. I mean, I think it's with mandatory. There's a difference between fines and fees. Fines with DWI cases are mandatory, and those need to be paid. There's provisions for time payments, and I'm completely comfortable with that. As to fees, and there's a penalty assessment that goes with every fine, be it a DWI or anything else, and that's mandatory also. But when it comes to fees, the essence of discrimination is treating people who are similarly situated differently. Somebody who can afford to pay for this program is situated differently than somebody who is in some form of economic distress. And so I think forcing the person who is poor to pay, even though they are not in the same financial condition as someone who is wealthy, is discriminating throughout the criminal code. The courts make distinctions between make distinctions based on somebody's financial condition. I see there's no reason not to do that here. I think it's unfair. So I'm going to oppose the amendment. I'm fully in support of the underlying bill, but I'm going to oppose the amendment.
To be clear, I don't suspect without this amendment, this will go forward. Having said that, I also, the way I see the discrimination argument you just made, when everyone gets in the car and sits behind the wheel, they are similarly situated. Doesn't matter how much money they have, how poor they are, their life circumstances. When they get in the car, they know the law. They equally at the same time choose to break the law. The person who has the money, person doesn't have the money, doesn't matter. They both know the penalty of what they're doing and choose to do it anyway. So I don't see that the person who happens to have money should be penalized more than the person who didn't when they made the same decision when they were similarly situated at no cost to themselves. Having said that, I'm going to ask the clerk to call the roll to adopt the amendment. Oh, stand by. I thought you meant for the whole bill. Okay. All right. We're going to take a 5-minute recess.
She listened, and I really would like to support. Okay. And then we still hopefully do have the bill. All right, come on, guys. Either way, yeah.
I am reopening the executive session. I believe it's on House Bill 602. Is that correct?
that is correct.
And the motion on the floor is to adoption of the amendment. And I'd ask the clerk to call the roll.
Vice Chair Rhodes,
Yes.
Representative Prue,
Yes.
Representative Lascelles,
Yes.
Representative Devoid,
Yes.
Representative Gagny,
Yes.
Representative Labrie,
Yes.
Representative Saborn Deschenier,
Yes.
Representative Tudor,
Yes.
Representative Harry Gathright,
Yes.
Representative Muse,
Yes.
Representative Newman,
Yes.
Representative Murphy.
Yes.
The clerk votes no. Representative Newell,
No.
Representative Shear,
No.
Chairman Roy,
Chair votes yes.
13-3.
13-3, the motion carries. The amendment is adopted. The bill is now open for further motion. I recognize Representative Murphy to make a
Oh.
motion.
Thank you. Move ought to pass as, this was a replace all amendment, so we're good to go.
Second. I think we've discussed this pretty good. I would just say that the program did show good results, so I have high hopes for it. So with that, I ask the clerk to call the roll. The motion is ought to pass as amended.
Vice Chair Rhodes,
Yes.
Representative Prue,
Yes.
Representative Lascelles,
Yes.
Representative Devoid,
Yes.
Representative Gagny,
Yes.
Representative Labrie,
Yes.
Representative Saborn Deschenier,
Yes.
Representative Tudor,
Yes.
Representative Harry Gathright, Representative Muse,
Yes.
Representative Newman,
Yes.
Representative Murphy.
Yes.
The clerk votes yes. Representative Newell,
Yes.
Representative Shear,
Yes.
Chairman Roy,
Chair votes yes.
16-0.
16-0. Any objection to consent? Seeing none, it will go on consent. I hereby close the executive session. I hereby open the executive session on House Bill 609 and recognize Representative Saborn Deschenier to make a motion.
Thank you, Mr. Chairman. I move we retain this bill.
Seconded by Representative Rhodes. Would you like to speak to your motion?
Yes, sir. So to put this succinctly, this is a very complicated bill that needs a little bit more work, and I think we should move this to the fall. I don't know how to say it any other way.
Would you like to speak to your second, Representative Rhodes? I agree with everything you said. Any further discussion? Representative Muse.
This is a terrible bill. There's absolutely no way we should be doing any additional work on this. This is a bill that should be ITL'd.
Thank you for that contribution. Any further conversations? Seeing none, I ask the clerk to call the roll. The motion is to retain.
Vice Chair Rhodes,
Yes.
Representative Prue,
Yes.
Representative Lascelles,
Yes.
Representative Devoid,
Yes.
Representative Gagny,
Yes.
Representative Labrie,
Yes.
Representative Saborn Deschenier,
Yes.
Representative Tudor,
Yes.
Representative Harry Gathright,
No.
Representative Muse,
No.
Representative Newman,
No.
Representative Murphy.
No.
The clerk votes no. Representative Newell,
No.
Representative Shear,
No.
Chairman Roy,
Chair votes yes.
9-7.
9-7, the bill is retained. I hereby open the executive session on House Bill 638 and recognize myself to make a motion. I move inexpedient to legislate.
Second.
I would start by saying this is a terrible bill and it should be ITL'd. I think that when someone is sentenced to life in prison without parole, the court means it. Society means it. We have the option as lawmakers to not sentence people to life in prison without parole. We can just sentence them to life in prison. The fact that we choose to make a crime so egregious that they have no possibility of parole means that we've thought about it and we find that behavior inexcusable and irredeemable. And the message it's supposed to send to the rest of society is that all ye who enter here, give up hope. Don't do it. So when we put a little light at the end of the tunnel, say, well, you know, when you get real old, we'll let you out. No. Further discussion. Second, Representative Rhodes, would you like to speak your second?
Thank you, Mr. Chairman. Yes, I would. I know that there was discussion that it costs $237 a day for a person that's incarcerated. But we have not discussed what the daily impact is on the victim's family. And additionally, this isn't a retirement system. I'm having a hard time with this aging out process. That I just have a hard time with that. But additionally, I think you have to think of the victims' families here, right? So what a person did to have a life in prison without the possibility of parole, that crime is so heinous that the judge ordered that for a specific reason. Every time this is brought back up for discussion, the family is notified, giving them no option but to relive the horror again, again, and again. And at some point, it has to stop. The closure has been there. Leave them alone. Just leave them alone. That's all I have to say.
Thank you. Further discussion. Representative Muse.
He
Representative
called,
Muse.
he called me Representative Muse.
I think one of the things to realize about this bill is this bill doesn't let anybody out. What this bill does is simply make these folks eligible to have a hearing. And at that parole hearing, as is the case with parole hearings for many, many other crimes, victims do have the ability to come to talk about the impact that the crime had on them. I think one of the other things I think we need to realize also here is that, especially in some of the cases that have come up and that this would apply to, one in particular is a veteran who actually committed murder. He was a Vietnam veteran who essentially had PTSD and was convicted of the crime at a time when we really didn't understand things like post-traumatic stress syndrome all that well with our veterans. He actually had a chance to plead to a lesser crime, but because of the guilt that he thought, the guilt that he felt around this, he actually pled guilty to first-degree murder, life in prison without parole. Since then, he's led an exemplary life. We had numerous people at the hearing talk about how this particular individual made a difference in their lives. And I guess the point is prison, to a large extent, is about punishment. There's no getting around it, especially when you're talking about crimes like this. But it's also about rehabilitation. And I think we need to be extremely careful about the circumstances where we put people behind bars with absolutely no hope at all, no matter how they change, no matter what they do. I think part of the reason for filing this bill is a recognition that people can change over time. And if they do change, then they have the opportunity to make their case to the parole board, which can decide either to parole them or keep them exactly where they are. I don't think there are any soft touches on our parole board. So the bottom line is I think that this is a bill that would affect a fairly small number of people. We see in the fiscal note it's about 15 people as of right now. And what I would challenge any of us to do, and I'm not sure if we're going to do this, but typically we take a tour of the state prison. What I would ask our folks on our committee to do if we take another tour is to look up some of these inmates and to ask yourselves, are these people who should still be behind bars? Or are the, not even that, but are these people who don't even deserve a hearing? Thank you.
Representative Prue.
So I'm on the other side of that coin because my brother-in-law was murdered, right? So he got a life sentence without parole to death, right? And I've been notified, my wife was notified that Oh, parole's coming up there was 2 accomplices. So every time we had to go relive that, right? That wonderful day of getting notified that he just got shot in the head. So, yeah. You know, if they've been put there for murder, there's no taking that back. You can't restore the life. They knew what they were doing. So they have to do the time. Sorry about that, but everybody knows that if you go that way, you're going to do time. You own it.
Thank you. Representative Murray.
Thank you, Mr. Chair. I just wanted to read out some data from the hearing that we had on this bill. I'm not really familiar with the individual that has been brought up in the hearing and now in discussion, but just generally, I think it's really important we allow for the process to ensure that we've made the proper judicial decisions in all of these circumstances, and not having the possibility of parole significantly impacts that. Up to 6 to 15% of people in prison are wrongfully convicted, and as many as 350,000 people, 100,000 people are in prison and are innocent. There was a doctor who came and testified on the bill who herself was a survivor of attempted murder and holds a doctorate in forensic psychology, and she has dedicated her life to these causes. And she shared that 2 out of 3 survivors of crime prefer shorter prison sentences if you combine that with prevention and rehabilitation services. 3 to 1 survivors prefer options for accountability other than prison. 3 out of 4 survivors support reducing prison sentences for someone who is actively engaging in rehabilitative services. And I just think it's important for us to give people, if we put people in prison for life with no attempt at parole, or no chance at parole, we're giving them no reason to try to be better people in prison, which is both dangerous to the people that are working there, their fellow inmates. And I think as a society, yes, there are absolutely horrible crimes that people need to, deserve punishment for. But I think everyone also deserves the chance to show that they've changed. And again, this isn't setting anyone free, it's just giving them the chance to make their case to the parole board. And I just think that's important, but thank you.
Thank you.
Lascelles.
Representative Lascelles.
Yes, I have a question for the committee as a whole. Is there any provision in New Hampshire law for someone who has been convicted and sent to prison for life without parole, who maybe under there might be new circumstances come out, not with respect to the guilt or innocence of the party, but the circumstances such as PTSD that comes out? Is there any provision for a retrial, not parole, but a retrial of that person based upon new circumstances?
It's my understanding that you can request a new trial based on new evidence that would be found to have made the jury, a reasonable jury, come to a different conclusion. Representative Scheer, is that correct?
Yeah, it's, with all due respect to the chair, it's more complicated.
Oh, I'm
than
sure.
that. There's a provision for a new trial when you come across new evidence that may affect the fact that somebody was found guilty or not. It's a much more difficult process to change, for example, a life without parole sentence when all you're really arguing about is, I shouldn't have gotten a life without parole sentence. Primarily because if in New Hampshire, if you're convicted of first-degree murder, it's a mandatory life without parole. It's not at the discretion of the judge. And that's the only crime for which you can get a life without parole sentence, other than capital murder, where the choice for a jury is either the death penalty or life without parole. So a judge has not exercised their discretion when they give a person a sentence of life without parole. They're required to by statute. So other than a pardon, which is extraordinarily difficult, there really is no provision to look back as to whether, unless it's a guilt innocence issue, to look back and say we don't want this person to be serving. So this bill is effectively operates to answer your question in a more positive way. That's really the effect of the bill. If there's something else I wanted to say, if I may, I'm in the particularly weird position of I've probably represented at least a third, if not half of those people serving life without parole sentences when I was trying homicide cases for the public defender program for 4 years. We'll put aside what that reflects about my skill as a defense lawyer. But you know, I know these people, and I appreciate, and I've talked with a lot of victims' families in these kinds of cases, and they're very difficult conversations, and I have an inkling, no more than that, because I'm not in that circumstance, but I have an inkling of the kind of pain they have suffered by losing someone in their family. I just, having been in the criminal justice system for over 40 years now, I can't see my way clear to abandoning the idea that rehabilitation is possible and that it's of some value to give a person incarcerated some hope under the narrow circumstances described in this bill. So I can't get all the way to saying we're going to throw away the key for certain people. That's just what I come out of my career as believing.
Thank you. So it's an interesting, we need to, I think, step back and look at something. If this is what we wanted to do, in my opinion, what we should do is change and get rid of life without parole. We should just put life, and then everyone's eligible for parole. But if we have life without parole, we shouldn't pay it lip service and say, well, we're just going to go around that. It's either life without parole or life. I was here 6-8 years ago. We abolished the death penalty. And that was the right thing to do. I don't think the government should ever be in the business of killing its citizens. We did that knowing that there was life without parole. And now, less than a decade later, we're saying, well, you know, while we're at it, let's go ahead and go around that. The right way to do this, if this is what we as a society want to do, is to do away with life without parole, not keep it and ignore it. And there's a plethora of other reasons that I just don't think this is a good idea. With that, we've had discussion. I'll ask the clerk to call the roll. The motion is ITL.
Vice Chair Rhodes,
Yes.
Representative Prue,
Yes.
Representative Lascelles,
Yes.
Representative Devoid,
Yes.
Representative Gagny,
Yes.
Representative Labrie,
Yes.
Representative Saborn Deschenier,
Yes.
Representative Tudor,
Yes.
Representative Harriet Gathright,
No.
Representative Muse,
No.
Representative Newman,
No.
Representative Murphy.
No.
The clerk votes no. Representative Newell,
No.
Representative Shear,
No.
Chairman Roy,
Chair votes yes.
9-7.
9-7, motion carries. An expedient to legislate. I need reports today, please. With that, I close the executive session. I open the executive session on House Bill 670 and recognize Representative Newell to make a motion.
I would like to make a motion to pass amendment number 2025-0325H.
Motion made and seconded. Would you like to speak to your motion? Do we all have the amendment?
Yeah, I handed
Okay.
it around to everybody.
Okay, I didn't see it.
And yes, I would love to speak to my motion. The sponsor of this bill brought this forward for a specific reason. And essentially what I heard from the testimony and that person introducing it was that this was for dogs that attacked. This is for vicious dogs. But there was in this bill, it also included raising the fine from $25 to $100 for what is a nuisance dog. So I wrote down exactly what it, and it references RSA 466, semicolon 31, 2, and this is what is considered a nuisance dog. So I just wanted to kind of clarify exactly what that means, right? It means that a dog is at large, which means it's off premises. This exemptions for hunting dogs and training and that kind of stuff. But if a dog is just running rampant around the neighborhood, and if it is barking for more than a half an hour during the day excessively or at night, and it's in a neighborhood, that is also another thing that's considered a nuisance dog. Or if it scatters trash, digs, scratches on someone else's property. So these are the three provisions that are what is considered a nuisance dog, right? So if we're talking about raising the first offense and all offenses for a nuisance dog to $100 from $25, that to me seemed excessive because we're not talking about a vicious dog. We're talking about a nuisance dog. So a dog gets out of the yard, we're talking about fining right off the bat $100. So I don't even think that was necessarily the intent of the sponsor. And I think it is well taken and support the rest of the bill, but I wanted to clarify kind of bring forward something that would be a little more palatable as far as what is a nuisance dog, the definitions I just described. And so what this amendment says is it changes one small section where it's referring to nuisance dog, not vicious dog, and it instead of changing 25 to 100, it says a warning will be for the first nuisance offense, $50 for the second offense within 12 months, and then $100 for the third and subsequent offenses committed within 12 months. And I think that this is actually consistent with what the sponsor wanted, and I think it's consistent with what we wanted to accomplish with this bill without necessarily throwing harsher penalties at someone whose dog gets out of the yard or does something that's not harmful, but is a nuisance.
Thank you. Who seconded that? Representative Murray, would you like to speak to your second?
I'm all set. Thank you.
Thank you. Any further discussion? Motion on the floor is to adopt the amendment. Ask the clerk to call the roll.
Vice Chair Rhodes,
Yes.
Representative Prue,
Yes.
Representative Lascelles,
Yes.
Representative DeVoid,
Yes.
Representative Gagny,
Yes.
Representative Labrie,
Yes.
Representative Sabor Duchenier,
Yes.
Representative Tudor,
Yes.
Representative Harry Gathright,
Yes.
Representative Muse,
Yes.
Representative Newman,
Yes.
Representative Murphy.
Yes.
The clerk votes yes. Representative Newell,
Yes.
Representative Shear,
Yes.
Chairman Roy,
Chair votes yes.
16-0.
16-0. Motion is, the amendment is adopted. I recognize Representative Newell to make a motion.
I make a motion to ought to pass with amendment.
Motion made and seconded. Any further discussion? Seeing none, I'd ask the clerk to call the roll. Motion ought to pass with amendment.
Vice Chair Rhodes,
Yes.
Representative Prue,
Yes.
Representative Lascelles,
Yes.
Representative DeVoid,
Yes.
Representative Gagny,
Yes.
Representative Labrie,
Yes.
Representative Sabor Duchenier,
Yes.
Representative Tudor,
Yes.
Representative Harry Gathright,
Yes.
Representative Muse,
Yes.
Representative Newman,
Yes.
Representative Murphy.
Yes.
The clerk votes yes. Representative Newell,
Yes.
Representative Shear,
Yes.
Chairman Roy,
Chair votes yes.
16-0.
16-0. And any objection to consent? Seeing none, I'll go on consent. I hereby close the executive session. Hereby open the executive session on House Bill 700 and recognize Representative Rhodes to make a motion.
Thank you, Mr. Chairman. I move ITL for House Bill 700.
Seconded by Representative Murray. Would you like to speak to your motion?
Thank you, Mr. Chairman. I think the last thing that we need to do when a survivor, a victim comes forward is question whether or not they are telling the truth. And additionally, I think that this bill is actually sending a message whether or not the victim should be believed. They already have to sign that they are telling the truth. And we don't have this provision when somebody comes forward with another crime. Burglary was mentioned. And knowing the conversations that Representative Murphy and I have often in this committee about families of victims and their survivors, this is just a bad idea, and this bill just can't pass.
Representative Murray, would you like to speak to your second?
I agree with everything Vice Chair Rhodes said. I think we shouldn't be putting further barriers in place of victims who are trying to come forward and receive action to protect themselves and to report a crime. And I think that while the sponsor may have had good intentions, it seemed very targeted towards one individual experience. And if the concern with taking someone's weapons away, if that's going to make them more violent, seems like they shouldn't have had those weapons in the first place. So I agree that we should be ITLing this bill.
Thank you. And to Representative Rhodes' point, when you fill out or a victim fills out an application for protective order, right on the paper, when you sign it, you swear to the truthfulness under the pains of penalties of perjury. If you go to court to support testimony of that order, you are under oath. I don't think adding a third time, promise not to lie makes a difference. It causes stigmatization of the victim again. If someone's going to lie, they're going to lie, and they'll eventually, hopefully, will come out. But one more thing is not going to make them not. So I agree. See no further hands raised. I'd ask you to call the roll. Motion is ITL.
Vice Chair Rhodes,
Yes.
Representative Prue, Representative Lascelles,
Yes.
Representative Devoid,
Yes.
Representative Gagny,
Yes.
Representative Labrie,
Yes.
Representative Saborn Deschrenier,
Yes.
Representative Tudor,
Yes.
Representative Harry Gathright,
Yes.
Representative Muse,
Yes.
Representative Newman,
Yes.
Representative Murphy,
Yes.
Representative, or the clerk votes yes, Representative Newell,
Yes.
Representative Shear,
Yes.
Chairman Roy,
Chair votes yes.
16-0.
16-0. The motion of ITL carries. I hereby close the executive session. On this next one. I hereby open the executive session on House Bill 767 and recognize Representative Rhodes for a motion.
Thank you, Mr. Chairman. I would like to retain House Bill 767.
Second, anybody? Seconded by Representative Pearl. I'd like to speak to your motion.
Thank you, Mr. Chairman. I do remember hearing the testimony on this bill, and I do remember, admittedly, I don't remember all of the details, but I do remember that there were some things in here we liked, but the way this was written was not necessarily going to be workable. But I definitely don't think that the bill should be killed. I would like to be able to take a look at it and have some stakeholders come back and talk to us about it and see what we can do.
Representative Pearl, would you like to speak to your second?
I'm good.
I seem to recall folks here from the department testifying that they were confused about it as well, or the necessity of it. So I agree. I'd like to look at it some more. Any further discussion? Seeing none, ask clerk to call the roll. Motion is to retain.
Vice Chair Rhodes,
Yes.
Representative Prue,
Yes.
Representative Lascelles,
Yes.
Representative Devoid,
Yes.
Representative Gagny,
Yes.
Representative Labrie,
Yes.
Representative Saborn Deschrenier,
Yes.
Representative Tudor,
Yes.
Representative Harry Gathright,
No.
Representative Muse,
Yes.
Representative Newman,
Yes.
Representative
Yes.
Representative Murphy.
Yes.
The clerk votes yes. Representative Newell,
Yes.
Representative Shear,
No.
Chairman Roy,
Chair votes yes.
14-2.
14-2, the bill is retained. I hereby open the executive session on House Bill 776. And recognize myself for a motion. I move on to pass. I recognize myself to address the issue. This is about, and unfortunately, you can't seem to pick up the paper without seeing someone else die for people driving down the wrong way on the highway. And invariably, they are highly intoxicated. So what this bill does is it turns OUI into aggravated OUI when you drive down the wrong side of the highway. I would argue that you have to be severely inebriated to do so. And it is so dangerous. It's so dangerous for numerous reasons, not the least of which being you're driving into people. But the faster you go and the faster people are coming at you, the mathematics behind that crash makes it virtually insurvivable when you hit somebody. Most times, no one's going to live. And we need to really drive this home to people that if you're going to drink and drive to the extent that you're going to go down the wrong way on the highway, you're going to be treated harshly by our criminal justice system. Further discussion. Would you like to speak to your second? Representative Murray.
Thank you, Mr. Chair. I agree with everything you said and wanted to add on to that. Lieutenant Storm, who had came and testified in support of the bill, mentioned that in Massachusetts they have detection systems that literally notify law enforcement when people are driving on the wrong side of the road, on the highway in particular. And, you know, here in New Hampshire, we have decided not to pursue things like that are tracking people while they're on the road. So I think we are kind of forced to go this route where we're, you know, seeking to put more punitive measures in place you know, in a compromise to protect people's, you know, freedom on the other side of it. And I think that this is a very serious crime. All of these accidents tend to be fatal accidents, whether to the driver or to other victims. And yeah, it really is terrifying how bad driving has gotten in this state. And hopefully increasing these penalties will make a difference.
Thank you. Representative Scheer.
Overall, I'm in support of this bill. As I was driving in today on down 95, across on 101 and up 93, all divided highways, I was thinking about this bill and thinking about a case that I tried, two different cases that I tried decades ago, where people were going down small one-way streets the wrong way, one in Nashua, one in Dover. I'm a little concerned that those kind of people are also going to be charged with aggravated DWI, and I don't think what we have in mind with this bill, as the chair has talked, contemplates that, but it's a little late for me to write an amendment, so.
I would hope that if it passes, you go to the Senate and bring that argument up, and maybe it could be on it. I think, though, it does say divided highway, doesn't it, on the bill? I'm not sure.
It says in violation of 265-26-1. To be honest with you, I haven't looked at 265-26.
Yeah. And another thing that occurred to me, too, as well. Yes.
Divided highway.
Yeah.
Thank you.
Yeah, they would still just qualify as being drunk drivers. Also,
Not in the two cases I
yeah.
tried, by the way.
Oh, really? I would say sometimes also which makes this scarier is they don't even have their lights on. And can you imagine, you know, someone coming at you at 80 miles an hour with their lights off, and you have no chance. You don't ever know what hit you. It's a horrific thing. And with summer coming, I hope we can pass this and get it into effect before we get a lot of tourists and a lot of drink and driving, and get this into the public awareness. At the very least, people might think in their foggies to make sure they're going the right way. Representative Scheer.
Again, it might be too late, but the effective date is January 1st, 2026. I guess we're stuck with that at this point.
At least until I introduce it in the Senate and I ask them to amend it. Representative Newman.
I just have a comment on reflectors that I've seen in other states. I've done a lot of traveling in other states, and I may have to mention this to my wife on Public Works. The reflectors are red when you're going the wrong way every time. At the end of each one of those, they're red. They're white coming when you're on the right direction and red when they're not. So.
That sounds like a lot less expensive and invasive thing than tracking people. I like that idea. Any further discussion on it? Representative Murray.
Thank you, Mr. Chair. I was just going to say in regards to the effective date, I believe most bills in our committee have a January 1st effective date for the following year because we're changing criminal penalties.
Thank you. Seeing no further discussion, I ask the clerk to call the roll. The motion is ought to pass.
Vice Chair Rhodes? Representative Prue?
Yes.
Representative LaSalle's?
Yes.
Representative Devoyd?
Yes.
Representative Gagné?
Absolutely yes.
Representative Labrie?
Yes.
Representative Saborn Duchenier?
Yes.
Representative Tudor?
Yes.
Representative Harry Gathright,
Yes.
Representative Muse,
Yes.
Representative Newman,
Yes.
Representative Murphy.
Yes.
The clerk votes yes. Representative Newell,
Yes.
Representative Shear,
Yes.
Chairman Roy,
Chair votes yes.
16-0.
16-0. Any objection to consent? Seeing none, we'll go on consent. And with that, I close the executive session. That was the last of our House bills. I guess I'll see you guys when we get our first crossover bills.
Is that going to be before, not likely next week?
No, it will not be next week.
Okay, thank you.
At this point, it'd be too late for the calendar anyway, so we are off next week. Enjoy the nice weather. Thank you all for your help during this first session, and goodbye. Yes, reports today, please, due to the fact that we got to get these out for the calendar before you leave. Thank you.